that, Judge, we were expecting that the Chief Registrar, in following protocol, would be here to introduce you. I can't see my friend, the Honorable Chief Registrar. I will request you to please permit me to, to violate protocol a little and invite you. Justice William Ouko. Justice William Ouko is a very self-effacing man, but he's a man of very many accomplishments. So if you actually want to know, Justice William Ouko has served in the magistracy. He has been registrar of the High Court for very many years. I remember, I think when I was in journalism, that's where he was, basically running the entire court system in Kenya. That's what the registrar does. He knows there's no court that you can talk to him about that he doesn't the location and how it looks and how many whatever it has. And then, of course, he was appointed judge of the High Court and subsequently judge of the Court of Appeal. Now, this is not known to very many people, but Judge William Ouko is also my uncle. We are related. Yeah. Yeah, I have people in high places. I know people in high places. No, I'm only pulling your leg. But he's a very amiable person. And when I worked at the judiciary and got an opportunity to see him at close range, he was one of my great protectors. So one of the things that I learned about Judge William Ouko is that he's very poetic. And so if you are actually looking for those occasions, if you are looking for those occasions that require somebody who chooses his words and knows just the right word for the right moment, that would be Judge Ouko. So I remember, I think we were honoring a retiring justice of the Court of Appeal, Justice Onyango Otieno, judge, if you remember, in Kisumu. And so he had this citation, and it was just one of the most beautiful things I have seen anyone ever turn out in a very, very short span of time. I'm telling you that because sometimes in the drab drudgery of doing judicial work, and I know that right now the Court of Appeal is extremely stressed. There are only, I think, 15 judges with 12 of them active, covering the whole country. So, they get pressed. But when those judges do have a moment, explaining, and I think I learned this from one of the judges, I think in the Supreme Court, that the most critical part of a judge's role, other than delivering justice, is also to explain to you why you have lost. Because sometimes people come and begin attacking the judicial system because their cases are not succeeding. I'm very grateful, and I think Kenya is very lucky to have people like Justice William Ouko, who can not just explain in prose, but they also explain in poetry. He has a lot of experience interacting with the media, both from an administrative role, but also as a judicial officer, and now as the president of the Court of Appeal. And I'm sure he has interesting perspectives in terms of how media relates to the judiciary and how it reports and what we can do with that relationship. Our chief guest, the Honorable Justice William Ouko. Karibu sana.
That didn't sound like myself being described, but I don't want to contradict him, because as he says, if he's my nephew, if I touch his ear, he goes deaf. So I will not thank you, Contesi, for those very kind remarks. The Vice President of the Editors Guild, Samuel Maina, David Moyo, the Chief Executive Officer of the Media Council of Kenya, council members and trustees of the Guild, Rosalia Omungo, who received me when I got here, the Chief Executive Officer of the Guild, Phyllis Ombonyo, the Chief Family Health International. I found the title of the organization, the title rather interesting. Faye Heselkon, the acting chief democracy, governance, and conflict of the USID, members of the Fourth Estate, and gentlemen. I didn't walk alone. I came with an officer from my office, Mr. Benjamin Kinuthia, is at the back. We support, moral support. I bring warm greetings from the Honorable the Chief Justice of the Republic of Kenya, who is also the President of the Supreme Court, the Honorable Mr. Justice David Maraga, on whose behalf I am here. For me, it's an honor to have been invited by you to make a few remarks as you launch the court reporting guidelines, which will no doubt go a long way in enhancing the quality and accuracy of reporting from the courts. Ensure that the media, as the fourth pillar of democracy, effectively plays its cardinal role of communication and education by providing the facts and opinions that shape perspectives on many topics of the day and also influence government action and public policy on critical issues of our society. Covering courts is an important task for several reasons. First, reporting court cases fulfills the part of the watchdog function of the media. Secondly, there is a great deal of public interest in what the courts do, both in criminal and civil cases. Coverage of the courts can also expose unfairness in the system, either for accused persons, victims, or parties generally in a dispute. May also help prevent injustices by shining spotlight on the actions of judges, lawyers, prosecutors, parties, and other participants in the justice system. Despite the importance of courthouse reporting, judges, lawyers, and members of the public often complain about reporting that is inaccurate, biased, or short on content. To some, this is because those sent by media houses to do stories about cases in court have no or little training about the complexities, the processes of the court, and its terminology. Some do not take time to understand the facts and how the law has been applied to those facts. Of appreciation of basic things like the structure of the judicial system of the court. And I'm glad, looking at the guidebook, that the structure has now been spelled out for the reporters. There are, in addition, isolated instances of laziness and shortcuts, where reporters merely rely on third parties for their stories without verification with the source, or by drawing conclusions in matters that have not been tried and determined on merit. And I want to draw two instances, most of them quite recent. The first one is where there was a report in the newspaper of an outcome of an appeal whose judgment was yet to be delivered. And the question we asked, where did you get the judgment? Of course, I think it is Dr. Nyamboga who said that these days things have changed. In the past, the author of that story would have been someone to come to court to explain the source of that story. Quite embarrassing for the judges who are involved. They were still in the process of drafting the judgment, but here it was in the newspaper with the details of the parties and what the court said and how one party lost. That was not a very good thing. So what happened? The three judges recused themselves and the matter had to start afresh. Again, delaying the matter further through careless reporting, where there were many parties involved. Several in hundreds had sued an institution of government, making some claims, and they won the case, but the newspaper reported that they had lost. So you can imagine what happened to those thousands of people who had sued, reading in the papers that they had lost, yet they had won the case. Stories obtained and disseminated recklessly without ascertaining their correctness have attracted civil litigation, as has been said here by those who spoke ahead of me. This has led to media houses paying colossal sums of money in damages for misreporting, which were seen as defamatory. A small story occupying less than a quarter page, an award in damages of 6 million is not a joke. If you are a reporter and you are making the media house for which you work pay 6 million for your reckless reporting, if you are to be dismissed by the media house and you came to court for, this is a joke, to ask to be reinstated or to ask for damages, the court might not sympathize, because courts also are victims of misreporting, and courts are presided by human beings who will, in the instance in question, may feel biased against you. So we must always remember that whatever we report must be accurate. You must be in a position to defend it with facts. Be very, very careful. Issues of content also come to mind, that if you report something that is not true, or if you scandalize the court in the manner in which you report, that you can actually be cited and be committed for contempt. Be you as the reporter. This again, as Dr. Nyamboga talked about it, has gone down. We do not have many journalists being committed for contempt of court. The last major one was in 1994, if you can all recall, and David McCalley, contempt that was tried in the Court of Appeal. I say it's an unfortunate blot in our jurisprudence. It was a matter, if tried today, perhaps they would have been just warned if they were found to have made a wrong report. Article 50 of the Constitution of Kenya grants every person the right to a fair trial. It is therefore important that reporters covering court sessions adhere to professional excellence by observing the basic tenets of journalism, which include accuracy and checking for facts to avoid a possible conflict between freedom of the media and the rights of a fair trial parties. In addition to this, and I believe the guidelines have adequately addressed it, and I've also had a speaker talk on the question of sub judice, a rule which regulates the publication of matters which are under consideration by a court if the publication creates a substantial risk that the course of justice in the pending proceedings would be impeded or prejudiced. We in the courts have our own share of blame. We make comments that are unnecessary, but which convey an unintended message and which may be taken to point to the direction of the ultimate outcome. Ruling on bond, for example, the court cannot be had to hypothesize on how there is a certain trend of committing certain offenses by members of the family, and how it is our duty as a court to punish those involved. Last week, and I couldn't believe that at the point of ruling on whether to grant bail or not, the officer goes on to say stories about how there's a trend nowadays in the country, families are involved in committing certain crimes. That, to a layman, would convey the message that this person before this officer, his goose is cooked, because the officer has already said, you know, you and your wife and your children, we are seeing this very often, and therefore you must have done it. We are not supposed to make such remarks. Such remarks, if at all, can only be made at the conclusion of the trial and when a basis has been laid for drawing such conclusions. Why do courts like the use of legalese in their decisions? Yet a large majority of those to whom those decisions are meant are not versed in technical legal language. Again, this is addressed in the guide. We'll hear and read words and phrases, which again have been defined in that guide, words like de novo. Yeah, that the three judges who recused themselves had, through that recusal, the cases, or rather the matter had de novo, but I decided to use the word afresh because that's what it means. So why do we use words like inter alia? Why do we use a fortiori? Why do we use ab initio, compos mentis, justem generis? Why do we use this to litigants who really do not understand this? They don't even care what they mean. They just want to know in a simple language what you are communicating through your decision. Words, other than anything else, are capable of causing serious confusion, and even to those who are learned in other fields. Why judges speak softly? I mean, in court, not out here. If you meet a judge in a podium like this, you can hear me. Sometimes in social places, you can hear judges, you know, really talking loud. But when you go to court, they just murmur. And have you ever asked yourself, why do judges speak in low tones in court, even when something is so serious? I have no answer why they do that. But I know that many people leave courtrooms and ask what transpired. Even when the proceedings, even when the judgment was read in a language that they understand. Ask, what did the judge say? But they sat in that court and listened through the delivery of the judgment. Our own Directorate of Public Affairs and Communications at the judiciary have been very useful or helpful. It has not been very proactive in helping reporters and the court in providing what Concesi talked about, the summaries of the court decisions in controversial matters or in matters of public interest. We have a directorate. We only see it when it sends a summary of media, daily media reports, newspaper reports. We only see it when we have a complaint that we have been misreported in our decision. Time to engage the media at the time delivered. They do not provide summaries, although in many courts, summaries are now provided, like in the Supreme Court. They summarize for you the judgment so that you do not make a mistake if you do not understand it. It is because of the above and many other challenges confronting court reporters in the course of their daily work that I highly commend the Kenya Editors Guild for taking this initiative to review and update court reporting guidelines in order to promote reliable reporting from the courts. With these guidelines, journalists covering the court beats will be fully equipped with the requisite resource and tool. The guidelines present a learning opportunity for reporters. It remains a technical area which requires constant reading. Indeed, apart from reporting in a war zone, court reporting may actually be the most demanding assignment for a reporter. For court reporters to acquaint themselves with the court system, language, and procedures to effectively carry out their duties. It's not a simple pen and pad affair, although, as I said, it's perhaps next to a war zone, and that's why I think those who spoke earlier said the first place you are sent perhaps is the court to go and war zone. And so it's not a pen and pad affair. You have to understand the procedures, you have to understand of the court. It will be observed that these guidelines are being launched in the midst of a global pandemic, COVID-19, which has created a disruption in the traditional media as we know it, and has led to the growing social media as a purveyor of news and information. However, the need and the duty of journalists to report accurately and to verify facts before going to press remains. At all times, court reporters must be prepared in the discharge of their work to stay on the straight and narrow path of the many offenses created under the Kenya Information Act, and to abide by the edict of the provisions of the Media Council Act. Challenging times have driven all of us to shift to a new normal. The judiciary has made adjustments to ensure the workflow in the courts is not interrupted for both judicial officers and reporters. We therefore endeavor to provide conducive working environment for reporters like the Media Center at Milimani Law Courts, to be replicated in all court buildings in the major cities. As the courts continue to conduct business largely on remote platforms, to be part of those proceedings by being invited to join the video links. Colleagues, the judiciary is committed to protecting the rights and fundamental freedoms guaranteed to the media in Articles 34 and 35 of the Constitution. But remember the limitations, especially that in the exercise of your rights, also respect the rights and the reputations of others. We shall continue to work together for the benefit of the people we serve. And today's launch of the guidelines heralds the next most critical phase to train and sensitize the end users of the guidelines. The judiciary, through the Judiciary Training Institute, is ready to partner with the Guild in this initiative, which hopefully can be carried out in all the counties to ensure uniformity. Colleagues, I wish to congratulate the Kenya Editors Guild and the project partners initiative and for inviting the judiciary to be part of it. I thank you all for listening to me, and with that, I formally launch the Guide to Court Reporting in Kenya. Thank you.
Thank you very much, Judge Ouko. I will now invite Rosalia, Phyllis, Fatma,